Good afternoon. Welcome to the Administrative Law and Regulation Practice Group lunch panel session. My name is Aram Gavor. I'm the chair of the practice group, and with my vice chair, the Honorable Beth Williams, we welcome you. Administrative law has had a whole lot of changes over the past several years. And today's panel, titled The Forces Shaping Administrative Law, Executive Courts and Beyond, really sets a nice framework for us to think about the broader doctrinal trends, separation of powers, the interaction between the executive branch and the judiciary, as well as the executive branch and Congress. With us as our moderator is the Honorable Michael B. Brennan, who was confirmed and sworn in as a circuit judge for the Seventh Circuit in May 2018. He previously worked as a partner at a Milwaukee law firm, Gass, Weber, Mullins, where he tried cases, handled appeals in federal, state courts, and as a judge in Milwaukee County Circuit. So, without further ado, please give a round of applause to Judge Brennan and our panel.
Thank you, Aram. So you can go back to the 1998 volume of the Harvard Journal of Law and Public Policy to find some of the first criticism of the Chevron doctrine and its requirement that courts defer to agency interpretation of ambiguous statutes that those agencies administer. 26 years later, in Loper-Bright, the court overruled Chevron and continued the project of refining and revising administrative law and the boundaries of it. We're here to consider some of the post-Loper-Bright landscape of ad law, including the continuing force and potential abrogation of Humphrey's Executor as implicated in the court's Trump versus Wilcox order, the means by which administrative law is being refined and revised, which is often the emergency docket, and the remedies available to do so, the limit on universal injunctions in Trump versus CASA, and its redirection of those seeking broad relief to other tools like class actions or targeted stays. What do these changes in administrative law mean for agency design and discretion, agency independence and accountability, and for litigants' strategy as part of the enforcement process? Our distinguished speakers are going to speak to these and related questions. Our panelists, in the order of their first remarks, are as follows. Gary Lawkowski is currently Deputy Assistant to the President and Deputy Counsel to the President. He was previously a partner at the Dillon Law Group, where his practice focused on political, election, and administrative law, appellate work, and nonprofit issues. Before joining the Dillon Law Group, he served in various capacities at the U.S. Department of Interior. He also served as a senior policy advisor at the White House Domestic Policy Council, as well as counsel to the Federal Election Commission. Gary earned his law degree and undergraduate degrees at the University of Virginia. Professor Ilan Werman is the Julius E. Davis Professor of Law at the University of Minnesota. He writes primarily on the 14th Amendment, administrative law, separation of powers, and constitutionalism. His academic writing has appeared in many leading law reviews, including the Yale Law Journal, Stanford Law Review, University of Chicago Law Review, and others. He is the author of an administrative law casebook from Foundation Press, and he has a number of books published or forthcoming from Cambridge University Press on the topics of originalism, the 14th Amendment, and the Constitution of 1789. He practices law with Tully Bailey, and he has litigated a variety of administrative law and constitutional law cases. He served as a law clerk for the Honorable Jerry Smith of the U.S. Court of Appeals for the Fifth Circuit. Professor Kelsey Brown Corcoran is the Supreme Court Director at the Institute for Constitutional Advocacy and Protection and a senior lecturer at Georgetown Law Center. She joined the Institute to expand its Supreme Court practice in response to the growing need for public interest litigators with specialized expertise in defending constitutional rights before our nation's highest court. She has served as lead counsel in numerous merit cases before the Supreme Court, and she has argued over 30 cases in the courts of appeals, including 12 of the 13 U.S. Circuit Courts of Appeals. Immediately before joining the Institute, she was the head of the Supreme Court practice group at Orrick, Harrington, and Sutcliffe. She previously served as a law clerk for the Honorable Ruth Bader Ginsburg at the U.S. Supreme Court, and Judge David Tatel of the U.S. Court of Appeals for the D.C. Circuit. The Honorable Beth Williams is a board member of the Privacy and Civil Liberties Oversight Board. She previously served as the Assistant Attorney General for the Office of Legal Policy at the U.S. Department of Justice from August of 17 to December of 2020. In that role, she served as the primary policy advisor to the Attorney General and the Deputy Attorney General, and as the Chief Regulatory Officer for the department. She's also led the judicial nomination process for the Department of Justice, assisting in the selection and confirmation of more than 230 Article III judges to the bench, including many of the judges here and including me. Before becoming Assistant Attorney General, Beth was a litigation and appellate partner at Kirkland & Ellis, where her practice focused on complex commercial, securities, and First Amendment litigation. She clerked for the Honorable Richard Wesley of the U.S. Court of Appeals for the Second Circuit. Before we jump in, a quick word on format. This session could easily span a couple of hours. We're limited to about 75 to 80 minutes. Each of our panelists will give a thesis statement of approximately 8 minutes. I will then ask the panelists to respond to each other's remarks in a roundtable fashion. After we move through at least one round of responses, we'll open up the discussion for other comments, and then that will be followed by questions and answers from the audience. So we'll hear now from our panelists, beginning with Gary.
Thank you, and thanks for having me this afternoon. So I'd like to begin kind of with first principles, go from there to what the administration's been doing, then kind of close out with litigation, which I suspect we'll get into a bit more as we go through this. So first principles, I think for this group, that's kind of the remedial education portion of the CLE. I suspect a lot of you are very familiar with these arguments and very familiar with kind of where we're coming from on executive power. But to help frame this discussion, I view it as largely there are two questions that are competing when we're talking about administrative law and executive power and how these things interact. First is kind of who decides, and second is what is the substantive decision. And if you kind of look at it through that lens, I think that provides a lot of insight into what's happening and why the courts are coming out the way they are, why the administration's doing some of the things we're doing, and how we're getting where we're going. So let's start with those first principles. The Constitution establishes 3 branches of government. It doesn't establish a 4th twig off here that's the unaccountable administrative state. It's the legislative, executive, and judicial branch. Within those branches, as we all know, it vests the executive power in the person of the president. As the courts noted, that's the only branch that is a person. It's not a body of 100 people like the Senate. It's not the House. It's not the judicial system. It's the president. That's the person who has the executive power. He also has the duty to take care that the laws are faithfully executed. That's a personal duty upon him to figure out, all right, he has to sit there and he has to think, how do I make sure the law is being executed in the proper way? Now, as the court explained in Celia Law and elsewhere and a number of other places, faithfully executing the law requires some degree of control over your subordinates. You know, I work for the president. I love the president. He's great. If I go and do something dumb, though, he has to have a recourse. Otherwise, how can he control what I'm doing? How can he ensure that I am faithfully executing his vision for how the law is faithfully executed if there's not some sort of recourse? That's where you get into removal and these other things. If you can't remove federal officials who are doing things that are contrary to the president's vision for how the law is faithfully executed, how can he possibly perform his duty? There's some sort of free radical actor out there who is no longer subject to that control. Now, and that gets into kind of the second part of first principles of why is that a problem? The more practical reason for this, and ultimately the key part of it, is democratic accountability. The president's the one who went out there, he campaigned for years, he got 77 million votes, he won the popular vote, he won the Electoral College. He's the one who came to you, the American people, with his vision and said, here's what I want to do. Here's how I think the law should be executed. Here's the policies I would like to enact. He's the one that people voted for and people bought into that vision for. It's not the person at an agency. It's not the undersecretary of what have you. Take a specific example. I mean, I would imagine if you walked down the street and asked, what's the Office of Special Counsel and who is it? You'd get a lot of blank looks. Maybe some people would talk about, past special counsel investigations. I don't know that they would get, though, to the formal Office of Special Counsel. I don't particularly think they're going to recognize, maybe a few people in this room might because of past experience, but I don't think you go down to DuPont Circle and ask people who's Hampton Dellinger, you're going to get a whole lot of answers. If you ask them, though, who's Donald Trump, I bet you every single person knows who that is, because that's the person who campaigned, that's the person who got 77 million votes, and that's where the democratic accountability comes in, of having someone who the people supported and who the people came out and voted for. So now, within that framework, all right, we've established the first principles. The president controls the executive branch. He's responsible for what happens in it. He has this duty to ensure the law is faithfully executed. So what have we been doing on that front? How are we kind of making that happen? So there's been a number of executive orders in that direction that are setting the table and kind of setting the stage for the president to exercise effective control over the officers he's supposed to be exercising effective control over. So take one example, Executive Order 14215, ensuring accountability for all agencies. If you really follow the law closely, you may have heard of it. If not, it's tough for these things sometimes to break through. But this brings regulations from independent agencies into what's called the 12866 process. This is a OMB review process of administrative actions and regulations. This says, hey, these so-called independent agencies really need to be coordinating with OMB and with the policymakers to make sure they're not going off on their own. Again, make sure that the person who 77 million Americans voted for is setting the policy, not someone that the average American couldn't pick out of a photo lineup if you made them. It calls for greater coordination on those policy matters, and it directs that the president and the attorney general ultimately set the legal interpretation for the federal government, for the executive branch. That's important because, again, the president's the one with the duty to take care that the laws are faithfully executed. The buck stops down there in the Oval Office at that resolute desk. It doesn't stop somewhere else. It doesn't stop at the commission for commissions or what have you that might be out there that might be trying to set its own policies. Ultimately, there needs to be someone who can set a legal interpretation for the executive branch, and at the end of the day, that's the president. And this executive order kind of recognizes that principle. Executive Order 14219, ensuring lawful governance and implementing the president's Department of Government Efficiency Deregulation Initiative. This, along with a couple of memorandums, focuses on repealing unlawful regulation. I think we're going to talk about Loper Bright and a couple other cases. These orders direct the agencies to go look at that case, to look at a few other cases, and say, hey, how many of our regulations are really based on the best statutory interpretation? How many of these are kind of a fuzzy, maybe we'll get Chevron, maybe if we squint real hard, we can kind of get to where this is ambiguous. Who knows what the means? It could be anything. So this is kind of getting at that and saying, hey, we need to go back and take a hard look at this, see how many of our regulations are really based on the best statutory interpretation, and where they're not, we need to go back and fix that. We need to actually go back to those first principles and to those controls where we're actually implementing the laws that Congress gave us, rather than something that an unelected bureaucracy has cooked up over the past 40 years. Consistent with that, I think we're up to about 24 regulatory actions in process in response to that order, and hopefully that'll continue to grow as time goes, as we kind of correct for some of the mistakes of the past. We've also seen a couple other kind of significant regulatory executive actions. On the same day as a memorandum kind of implementing that order, there was a order on maintaining acceptable water pressure in shower heads. Now, this is important for a couple reasons, not just because personally I kind of like more pressure out of the shower head. I don't want to be walking around with soap. Thank you. Yeah. So I fully support the policy initiative there, but it's also important because what this did, and it's one of the few times it's been done, is the president directly repealing a regulation. He's the one who's responsible, again, for what the law is, and here he's directing the Department of Energy to directly repeal a regulation rather than waiting for a drawn-out administrative process. So it's an issue that, to some may sound petty, in the grand scheme of things affecting the United States, is shower head pressure the biggest issue? Probably not. It's a frustration, but it may not be the biggest issue as you're dealing with everything else the president's dealing with. But it's important because it establishes the principle that the president is in control of the executive branch, and he can help repeal some of these regulations where they've gone off the rails. We've also had a couple of other deregulatory EOs. So there's the 10-to-1 EO, trying to repeal 10 regulations or pull back 10 of these things for each new one we're adopting. There's also a focus on regulatory mens rea. That one was near and dear to my heart. That's making sure there aren't surprises as people go through. There are more regulations and more regulatory crimes than DOJ or anybody else in the country can count. Possibly hundreds of thousands of things that are in the Code of Federal Regulations that you all can be held criminally liable for, and nobody really knows what they all are. We're going to fix that. We're asking agencies to go through and identify what those are. We're asking them to disfavor strict liability, particularly in regulations, so that people actually have to have an idea that something's out there. They don't get jammed up with, oh, well, the commission passed this thing 20 years ago. Nobody's ever heard of it, but you violated it. You were walking your dog on a national park without a leash. We're going to throw you. No, we're not going to do that anymore. We're going to go back and look at that and have kind of correct that and disfavor strict liability regulations and try to make sure that people understand what's expected of them through these regulatory crimes. But now, as you might expect, some of these energetic executive actions have provoked we'll say, a legal reaction. It's provoked, frankly, a coordinated legal campaign. This is similar to what we saw during the presidential campaign. I worked on the legal effort there. There's a coordinated effort, for example, to throw the president off the ballot under these crazy 14th Amendment theories. Fortunately, the Supreme Court rejected some of those approaches and kind of the way it was being done. We're seeing something similar happen now to try to stymie the president's agenda. And if you don't believe that this is kind of happening, I'd point you to an Atlantic article where Norm Eisen is happily bragging about doing this, about going out and bringing hundreds of lawsuits to try to stifle and dam up the president's agenda. So if we go back to my original kind of framing of, there's kind of two questions: who decides and what are the substantive issues? We can see what's happening with this legal campaign against the president's executive actions, particularly in the administrative space. People are unhappy with the substantive outcomes. That's to be expected. We're a large pluralistic country. There are a lot of people with a lot of different views. A lot of people have a lot of different opinions. People are going, even if the majority of the country is happy with something, there's probably going to be someone who's not. Even if 4 out of 5 dentists agree, there's still that one other guy who no one's really ever found and hasn't quite figured out why he doesn't like that. But rather than contest some of these actions in the political sphere, what we've seen is people turn to the question of who decides and try to change the locus of who decides away from the president and move it to some other agency, whether that's an administrative agency or the courts. And that's what's going on in a lot of this litigation. Now, this is a problem in both cases. It's particularly dangerous in the executive branch, though, because, again, the president ultimately is responsible for executive actions. He's responsible for what it's doing. You can't have these subordinates who aren't accountable to anyone, least of all the American people, running around doing things without any supervision. And that's the central factor in a lot of these removable cases that I think we're going to get into a little bit later. And it should be pointed out, the Biden administration was extremely active in removing executive branch appointees from different boards and commissions, all sorts of things that people probably haven't heard of. Maybe this room has, because this is a slightly, we'll say, atypical audience. But for example, the Biden administration removed Roger Severino from the Administrative Conference of the United States. That's another one of those things that I bet if you went down to DuPont Circle, you're not going to find a whole lot of people who can tell you what that does. But they reached down and removed him and ended up in a DC Circuit case that confirmed you can do that. Same thing with removing Sean Spicer from the board of the Naval Academy. So the Biden administration was very active in removing people, yet when the Trump administration comes in and does it, suddenly it's a national issue that needs to be brought in litigation in a bunch of different places. Now, the other place we can see this happening is the debate kind of over the use of the courts and the idea to try to shift things from the president to the court system and shift power to the courts. The debate over universal injunctions really highlighted that point. Nationwide injunctions allowed politically motivated plaintiffs to bring their cases in politically advantageous jurisdictions. It resulted in the possibility of any one of over 600 federal judges through 94 different judicial districts across the country being able to stifle the president's policy. The person who 77 million Americans voted for, the only national representative, is able to be stifled by a single district court judge in a district who may have no connection to the particular policy in some cases. This was taking power away from the elected leadership, from the American people, and putting it where it doesn't belong in the hands of unelected officials. And frankly, it also was bad for the development of the law. It stifled the ability to have circuit splits. It stifled the ability to kind of have different examinations and short-circuited that process. We got to a situation where it was so bad there were more universal injunctions, I think, in February against this president than there were against all the other presidents before then. That was not a sustainable situation, and luckily we were able to go to the Supreme Court and get relief from that in the Trump v. CASA case. Now, that was a good situation for us. That helps stifle some of this universal injunction fever where you have one district court judge shutting down everything for the entire country. However, as I think we'll get into a little bit more and some other people are going to talk about, it's not the end of the matter. There's a number of other administrative actions or a number of other kind of procedures courts have used to still go after the agenda and shift that authority. So to paraphrase Churchill, Trump v. CASA is not the end. It may not even be the beginning of the end. Hopefully it's the end of the beginning of this attempt to shift power away from the elected branches and where it doesn't belong. And with that, I'll move on.
Very good. Thank you, Gary. Alon.
Great. Thank you so much for having me and for being here. In my short opening time, I want to focus on the future of judicial review of agency statutes. So I'm going to focus on Loper-Bright, major questions, and arbitrary and capricious review. In particular, I want to do two things. First, I want to defend the court's recent doctrinal changes in this area. And second, I want to argue that they don't spell doom for the administrative state. First part being more important, right? Whether it's right or not is what I'm more interested in. Okay, so let me start by defending the proposition that the Loper-Bright case overturning Chevron deference. Chevron's an old doctrine. It's been gone for a year now, so if you don't remember what it is, Chevron was the case that required judicial deference to any plausible agency interpretation of an administrative statute, even if obviously not the right one or not the best interpretation. Well, the Loper-Bright decision overturning Chevron deference, in my view, I humbly submit, should have been a 9-0 opinion. That's because if you read it closely, which is, I guess, all what it's about, very little separates the best reading of the majority's opinion in Loper-Bright from the best reading of Justice Kagan's dissent, at least if that dissent is read in light of Kagan's prior opinion in Kaiser. So Kagan described Chevron step 1, which required courts to decide whether statutes were ambiguous. That was the interpretive step. She described it as follows. The inquiry, she said, is rigorous. A court must exhaust all the traditional tools of statutory construction to divine statutory meaning. But sometimes, she said, after all those tools are deployed, the statute remains ambiguous. Now, it's important to understand what she meant by ambiguous. She explained in Kaiser, first and foremost, a court should not afford deference unless the regulation is genuinely ambiguous. The core theory of deference is that sometimes the law runs out, and policy-laden choice is what is left over. So the bottom line, Chevron step 1, the interpretive step should be rigorous, but sometimes the law just runs out. Okay, let me say two things about this. First, her description of Chevron would be unrecognizable to most practitioners in the circuit courts. Take the DC Circuit's decision in Loper-Bright, which I think is representative. The majority concluded that the statute was not, quote, wholly unambiguous. There was still, quote, some question as to the statute's meaning, so they deferred to the agency. Is that really a rigorous inquiry? Okay, so that's the first thing. But the second thing I want to say is if the courts genuinely deployed a rigorous step 1, as Justice Kagan said that they do or suggested that they should, then I don't think anything in the majority opinion in Loper-Bright actually disagrees with anything in Justice Kagan's dissent. So Justice Kagan explained that sometimes the law just runs out. But if the law has run out, what are we interpreting? Kagan is quite right that all that would be left over in that case is delegated policymaking, interstitial gap-filling authority. But that's exactly what the majority also recognized. Channeling the late giant of the field, Columbia professor Henry Monahan, the majority wrote that sometimes the best reading of the statute is that it delegates policymaking discretion to the agency, to its reasonable, feasible, practicable. But that is the domain of arbitrary and capricious review, not interpretation. So it seems to me that the dissent was saying that courts should rigorously construe statutes, but sometimes the law runs out, leaving policy-making discretion to the agency. And it seems to me that the majority was saying that courts should rigorously construe statutes, but sometimes the law runs out, leaving policy-making discretion to the agency. Yes, I repeat myself. How is that not a 9-0 decision? Now, let me say something about the major questions doctrine, which is the other statutory interpretation development. I've argued in a paper called Importance and Interpretive Questions that the major questions doctrine is really best understood as a linguistic canon. Justice Barrett adopted also a version of this argument in the Biden v. Nebraska concurrence, though I think she probably goes a little farther than I would, but that's something we can talk about. I also wonder why this isn't a 9-0 proposition. So let me try to defend it. Okay, in a nutshell, the linguistic account of the major questions doctrine maintains that where a statute is ambiguous, It's entirely reasonable as a matter of how people understand language and how people deliver instructions to expect and demand more clarity the more extreme and significant the consequences. Now, as an initial matter, I think that empirically, all of the court's major questions cases in fact, meet this understanding. There's this threshold of ambiguity in all the statutes that were being interpreted in these major questions cases, and so the linguistic framework works. Take West Virginia v. EPA. The question is, what is the best system of emissions reduction? Well, a system could be the system within the plant, like the plant system itself, or it could be the nationwide energy system, which I don't think was too plausible, but that's what the Obama administration adopted. Okay, so it was ambiguous. It was ambiguous. And if there's a threshold of ambiguity, the major questions doctrine can be used to resolve that ambiguity. Okay, so if the doctrine indeed requires this threshold of ambiguity and is about helping to resolve those ambiguities, then I think it's perfectly consistent with textualism. Okay, if textualists resolve ambiguities by trying to ascertain which of multiple possible meanings the legislature likely intended, then this version of the major questions doctrine accurately accounts for the legislative process, as far as we know anyway. It's true that Congress often likes to delegate tough policy questions to somebody else. They don't want to take the political heat. That's public choice theory 101. And it's also true, as some have shown, that legislators often like to use strategic ambiguity. I guess that's public choice theory 201. The question, though, are legislators likely to delegate the resolution of really important major and tough questions through ambiguities, through oblique languages? That's the question, and as far as I know, there has only been one empirical study truly bearing on it. Others have claimed to publish studies that bear on it, but they don't really ask the right questions. So in that study, professors Abby Gluck and Lisa Bressman find that congressional legislators and drafters specifically state that they do not intend to delegate major authorities through ambiguous language, that they are clear when they intend to do big and important changes. Now, suppose textualists resolve ambiguities by trying to ascertain which of multiple possible meanings an ordinary reader would understand. Well, ordinarily, the recipient of a delegation or of information who is sensitive to the stakes at issue is likely to demand more clarity the higher the stakes. Now, Professor Ryan Dorfler at Harvard has written about this, and I took a lot of inspiration from him. I encourage you to read his paper. For now, in my short time, let me just say that there's historical support for that intuition, which I think is a common sense intuition. In the early debates over the necessary and proper clause, there was a question whether incorporating a national bank was too great and important a power to be left to implication. Everyone agreed that some authorities, like the power to tax or declare war, were too important to be left to implication. Madison summarized the point as follows, quote, "In admitting or rejecting a constructive authority, not only the degree of its incidentality to an express authority is to be regarded, but the degree of its importance also, since on this will depend the probability or improbability of its being left to construction." That just sounds like the major questions doctrine, circa 1791. The intuition persists in agency law. Here's the third restatement, circa 2000 something, maybe later. A reasonable agent should consider whether the principle intended to authorize the commission of collateral acts fraught with major legal implications for the principle. So it seems to me that everyone agrees with this intuition that some things just matter too much to be left to implication. It is that intuition, I think, that drives the major questions doctrine. Now let me make one final provocative point. Is the New York Times here? I mean, this is something they could possibly write about. And, it won't be that interesting, actually. I do wonder if this linguistic version of the major questions doctrine actually ends up supporting many substantive canons. It's actually quite controversial what I'm about to say. Think of the rule of lenity. We demand more clarity because the stakes are so high for the defendant. Or what about the charming Betsy canon? We demand more clarity because the stakes of violating international law aren't exactly trifling. Would Congress really have intended that? To put the point another way, what is important or major may depend on our substantive views of the law and the legal system. So maybe far less separates linguistic canons from substantive canons after all. And with those fighting words, I'll stop.
Thank you, Ilan. Kelsey.
Thank you. Thank you for including me in this discussion. So I am primarily a litigator. So for my purposes, once the Supreme Court says something that is the law, and it doesn't really matter what I think of it. So I am going to focus more on observations than opinions today, specifically with regard to the balance of power across the branches. And I think on that we might be in radical agreement on what's happened over the last couple of years. But I'll start with the 2023 term. We've talked about Loper Bright. I'm going to expand it a bit to Corner Post and Casey also. So we have a trifecta, which I think we agree was pretty seismic transfer of power from the executive to the judiciary. And specifically, it was a transfer of power from the administrative state. So we had Loper Bright transferring the power to resolve statutory ambiguities on regulatory challenges. Then you have, from federal agencies to courts, and then we had Corner Post, which eliminated the statute of limitations on regulatory challenges, so it reopened the entire Federal Register to judicial challenge, and then we had Casey, which shifted the adjudication of civil penalties from agencies to courts. There was also Ohio v. EPA. I don't include that in the trifecta because I don't think it was really announcing a legal rule, but it was a pretty muscular application of State Farm, as we know from Justice Barrett's dissent. So I think it's consistent with this trend. But I think where we agree, none of those cases involved the president's exercise of authority. It was these non-political rank and file agency experts. So in Justice Kagan's example, the FDA scientists who decide whether alpha amino acid polymers are proteins. And Loper Bright, a case about the National Marine Fisheries Service. What I think is really interesting about all of this is that I think arguably the trifecta has been overtaken over the last 10 months by the Trump administration's own kind of direct decimation of its agencies through mass layoffs, right? The FDA scientists that Justice Kagan spoke about are gone. And I Googled last night to see what was happening with the fishery services. Their website is currently frozen because of the shutdown, but it appears that they also have lost most of their staff. So, whatever disagreement I think we have about whether that was good or bad, I will be curious to see whether Loper Bright or any of these cases have much import now that the administrative state that was making a lot of the decisions that were challenged has largely been eliminated. We'll see. I think that the issue we would probably disagree on is how much value there is in what those bureaucrats were doing, right? Are we going to miss them if we have a salmonella outbreak or air travel becomes unsafe or we no longer have innovative cures to cancer? Time will tell on that. So I'll move to CASA. I did argue CASA on behalf of the plaintiffs. I will not redo my oral argument for my benefit and for yours. I will say, the question of universal injunctions isn't really one that was divided along kind of ideological lines. I know when I was preparing for argument, I listened to a Federalist Society podcast with Beth. Beth was arguing against universal injunctions, and my position was represented by Ken Paxton. And so I'm glad we agree on that. General Prelogger was, I think, the first Solicitor General who urged the Supreme Court to pull back on universal injunctions. Right? It's a what's good for the goose is good for the gander. There were lots of situations under the Biden administration where universal injunctions were considered a pretty effective way to stop the administration from doing things that folks disagree with. I will also say, seeking judicial review of executive decisions that people think are problematic constitutionally or for other reasons is also not a partisan issue. Of course, the states in Biden v. Nebraska didn't wait for the political process to play out before challenging the student loan forgiveness program. Neither did the plaintiffs who challenged the eviction moratorium or vaccine mandates. So I would say, in that sense, judicial review is playing out exactly as it should. Okay, so moving to CASA. I think it suffices to say there were numerous really smart and thoughtful legal historians who went down the originalist rabbit hole on non-party relief and came to different conclusions. With apologies to the many other very smart academics who are working on this, we generally refer to it as the Sam Bray camp, which was against universal injunctions, and the Mila Sohoni camp on the other side. You'll see that Professor Bray's camp won in the majority opinion. A few practical observations on that outcome. One is that throughout the argument and in the majority opinion and concurrences, there is an unquestioned assumption that while lower court decisions don't bind non-parties, Supreme Court decisions do. General Sauer agreed on this point in his colloquy with Justice Barrett about the point at which the executive branch would understand itself to be categorically bound by a judicial decision. He said not district court decisions, usually court of appeals decisions, and always Supreme Court decisions. General Prelogger took that same position, I think, during the student loan argument. And so CASA's limitations really involve not a transfer of power away from the judicial branch writ large, but from the lower courts. We probably agree on that as well. I think it's significant that CASA did not indicate any Article 3 problem with non-party relief. Article 3 features prominently in the academic commentary and gets some play in the government's briefs, and Justice Thomas mentions it in his concurrence, but it's not mentioned in Justice Barrett's opinion. That's important, I think, with respect to the Supreme Court's ability to bind non-parties. If it were an Article 3 problem, that would be a problem for SCOTUS as well. It's also important for APA vacator. So, not to get too remedial here, Section 706 allows courts to set aside unlawful agency action. For that, for vacator to stand under that provision, Congress has to have constitutional authority to statutorily empower courts to enter judgments that bind non-parties. As a practical matter, again, I'm more about observations and opinions. We know APA vacator is here to stay under the court's current composition. We have against it Justice Thomas, Justice Barrett, and Justice Gorsuch, and Justice Gorsuch's concurrence in U.S. v. Texas. But I would assume Justice Alito agrees, but we also have Justice Kavanaugh's concurrence in Corner Post, where he enthusiastically defends APA vacator, and then, of course, the Chief's quip about the D.C. Circuit vacating regulations 5 times before, or statutes, or regulations 5 times before breakfast during the U.S. v. Texas argument. So that's a 5-4 split right now. Again, though, that's a judicial power that's directed mostly at reining in administrative agencies rather than the president. The APA does not apply to presidential action. Okay, so moving on, what to make of the court's enthusiasm for class actions? It was clear going into the argument, again from past opinions, that class actions were the alternative to universal injunctions that the court was interested in, and also pretty clear that birthright citizenship was an easy fit for class treatment under Rule 23. That's exactly how it played out. We, I think, filed for class certification 2 hours after the court's decision came down and had, a decision, nationwide class maybe a week later. My biggest concern going into argument was retaining the availability of preliminary injunctive relief pre-certification under Rule 23. Certification can be very time-consuming, discovery-heavy, and requiring it for preliminary relief would also have been pretty ahistorical because it wasn't until 1966 that we even had a certification problem for class actions when Rule 23 was modified to include that process. So I spent a lot of time, if you listen to the argument, I talked a lot about how important it was that we be able to have preliminary relief for putative or provisional classes. The next day, the AARP decision came down, where the court was all on board with preliminary relief for putative actions. Putative class actions. I would love to take credit for that, but obviously they had already written that opinion, and I wasted a lot of energy at argument on that. I was glad for the outcome. So that is how, where does that leave us on universal relief? So as a practical matter, if the class is the universe of people impacted by the challenge action, preliminary putative class relief is the equivalent of a universal injunction. So any kind of deleterious impact of the court's decision would be limited to challenges where you can't articulate a class. That could be First Amendment overbreadth claims. Justice Kavanaugh suggested at one point that those were too complicated to think about in the context of universal injunctions, maybe vagueness claims. And some lower courts are beginning to hold that CASA doesn't apply in those circumstances. So I tend to think that maybe I agree with Gary on this, that it's the beginning, what was it, the beginning of the beginning of the, right, that it might not actually be that significant of a decision unless it's followed up maybe by other sorts of limitations. And then I will just quickly touch on tariffs. We had this big argument on Wednesday. I think that the press, at least the press I was reading, was overly confident about the court striking down tariffs. I think that's ultimately what will happen, and that it will be on major questions doctrine grounds. That's certainly where Justice Gorsuch seemed to be, and I think possibly Justice Barrett and the Chief Justice will go along with that. And so I'll just add to what Alon said when we're talking about shifts of power. It was interesting in Biden v. Nebraska when the court talked about the major questions doctrine, the majority described it as the executive seizing power from the legislature. The dissent described the major questions doctrines as addressing the judiciary seizing power to thwart the legislature's transfer of power. So it just depends, I think, on what perspective you're looking at it. Also underlying the major questions case in the tariffs case is the non-delegation doctrine, right? That is very clearly, I think, a transfer of power to the judiciary, where the judiciary is telling the legislature it can't transfer powers to the executive. So it's a pretty robust idea of judicial power. So what I will be looking for in the court's decision is, one, how they address the president's authority to declare emergencies and what sort of judicial review that is. In Biden v. Nebraska, President Biden was also basing his authority to cancel loans on the emergency, specifically the pandemic. Of course, many of the president's actions have been based on assertions of emergency as well. The administration took the position that emergencies are not judicially reviewable, so we'll see if that sticks. And then I'll also be interested in whether the court leaves space for other statutory routes for reissuing the tariffs. Justice Alito suggested at least one, so we'll see if the court says anything about that.
Thank you, Kelsey. Beth.
Great. Well, good afternoon. It's really wonderful to be here, and I want to thank Professor Gavor and the Federalist Society for the kind invitation. And of course, it's a pleasure to sit with and speak with Justice Brennan again and my fellow panelists. So I want to just
You've elevated me too soon.
So I want to, just an aside to Gary's point, as someone who may or may not have a closet full of incandescent light bulbs in her house, I appreciate some of the policy movements. But I also want to make my usual disclaimer. I'm speaking today in my personal capacity and not on behalf of my agency, which, by the way, neither regulates nor adjudicates. It's not quasi anything, so we should be fine. So the description of this panel is a broad one, but it lends itself to talking both about administrative law and separation of powers. And there's been so much discussion about the movement of executive power. I think it's important to focus a little bit, too, on the movement of judicial power, which is a lot of what Kelsey touched on. And I think here is the key point. What we're seeing both in Loper-Bright on the one hand and in CASA on the other hand is a return to proper judicial function, but in different directions. So let's start with Loper-Bright. Loper-Bright has been called by Professor Cass Sunstein as, quote, our Marbury. And I take that to mean the Marbury of the administrative law. And the court itself actually made that pretty clear. The court stated that Section 706 of the APA codifies for agency cases the unremarkable yet elemental proposition reflected by judicial practice dating back to Marbury that courts decide legal questions by applying their own judgment. That is, it's the courts, not executive agencies, that say what the law is. And despite all the worrying about the ways in which the Roberts Court is expanding executive power, the death of Chevron is really a return to textualism. And in that way, it marks a dramatic decrease in the power of the executive and associated restoration of judicial power. It's notable that some of the people who were most chagrined by Loper-Bright in the summer of 2024 softened their line a bit in November of 2024. The new Trump administration and successive administrations will no longer be given deference in interpreting their own statutory powers. And the extent and impact of Loper-Bright are really now playing out. It's going to be interesting to see what role stare decisis plays going forward. Some of that will likely depend on what the prior rulings themselves actually were. For example, if a prior court determined that a statute under Chevron Step 1 was unambiguous, then the holding could be seen to control regardless of Chevron's demise. But if a prior court ruled under Chevron Step 1 that the statutory language in question was ambiguous, then the current court might have to consider anew what the best reading of the statute is without deference to the agency's interpretation. So through Loper, courts have reclaimed the primary power of judicial review with respect to administrative law. At the same time in CASA, we're seeing the court reestablish limits to the judiciary's remedial power. CASA was, of course, about the power of lower courts to issue nationwide or universal injunctions, that is, to grant relief to parties outside of the case. The court held that the breadth of such relief was unlawful, and in doing so, it reaffirmed several threshold principles. First, federal courts do not have inherent, all-encompassing equitable powers. The Judiciary Act of 1789 endowed federal courts with jurisdictions over all suits in equity, and this statute today is what authorizes the federal courts to issue equitable remedies. Second, the statutory grant of power does not extend to all equitable remedies, but only those sorts of equitable remedies traditionally accorded by courts of equity at our country's inception. And as the court found, there was no remedy remotely like a national injunction. The court subsequently refused to grant relief to non-parties. Finally, the court said that when a court concludes that the executive branch has acted unlawfully, the answer is not for the court to exceed its power too. It's pretty clear that the court is also saying that not every official government action is subject to judicial review. To take it back to Marbury, Marbury is often cited for the proposition that there must be a remedy if there is a right. But Mr. Marbury, of course, never got his commission. The Supreme Court said that the statute granting the court jurisdiction conflicted with the Constitution. So while Marbury is known for vesting the court with the power of judicial review, the court, of course, did so by recognizing clear limits on its own power. The Supreme Court said we are not all powerful, and the Constitution limits us just as it limits the other branches. Justice Barrett clearly agrees with this, as she wrote in her recent book, Listening to the Law. She said there that the judiciary neither answers every constitutional question nor rights every constitutional wrong. The judiciary's province is to say what the law is only when the judiciary is authorized to speak. And that constitutionally is only when there's a legitimate case or controversy. Otherwise, the remedy is a political one. Now, with respect to CASA, it's important to note, just as Kelsey did, that the court ruled on statutory grounds, not constitutional ones. And I want to underscore that because that was a big deal. The court interpreted the Judiciary Act of 1789. It did not go so far as to say that nationwide injunctions violate Article 3's limitation of the federal court's powers only to cases and controversies. If the court had gone so far as to rule on constitutional rather than statutory grounds, the scope of the set-aside remedy of the APA would be deeply in doubt. So in my view, some of the most interesting jurisprudence in the next 5 years are going to be about remedies. After CASA, you're going to see litigants employing both class actions and APA suits to the greatest extent possible because of the scope of the potential remedy there. And so it will be interesting to see whether there are 5 votes interpreting set-aside to be limited to the parties to a particular case, or whether the original meaning of set-aside meant that the regulation should be set aside in its entirety as to everyone. So I'll stop there, and I look forward to the discussion.
Very good, thank you. All right, we've had discussion with regard to remedies, the scope of Loper-Bright, what's going to happen next. I want to open it up for commentary between and among our experts here. Talk about some of the comments that have been made, their agreement or disagreement with.
Okay, do we want to do judicial power or executive power? I actually am feeling kind of stressed by the choice, which I thought I would have a few more minutes to make. But let me start with judicial power, and then maybe I'll go back to the removal question, which is kind of interesting, just because I want to fight with everybody, because it makes these more fun. So starting with CASA, the same rule does not apply to the Supreme Court. That's wrong as a historical, textual, structural matter. The Supreme Court has no right to bind non-parties to a case. Now, there are concerns that don't apply to the Supreme Court, like a forum shopping concern, right? There's a wasting time concern. So the Supreme Court just ruled, are you going to bring, a new plaintiff's going to bring the exact same case you're wasting your time. Maybe at some point, good faith requires us to consider the question settled for a while, and maybe you can even sanction their lawyers or something. But if you take that rule too far, then Roe v. Wade isn't overturned. Then Plessy v. Ferguson isn't overturned. It just isn't true that the Supreme Court is somehow allowed to bind non-parties. So the Supreme Court decided the Dred Scott decision, and Abraham Lincoln said, great, your decision is binding on Dred Scott and John Sanford. It is not binding on the country as a political rule. It is not binding on me in my capacity as the President of the United States when I'm deciding whether free African Americans are citizens of the United States for purposes of the passport laws, for purposes of the coasting license laws. It was not binding on the United States Senate when they had to decide whether Hiram Revels had been a citizen of the United States for, do you know who Hiram Revels is? Anyone? Okay, thank you, Gabriel from Notre Dame. Precocious student right there. Hiram Revels was the first African-American senator in United States history appointed by the reconstructed Mississippi legislature in 1870. What was the problem? If Dred Scott was the law of the land, then Hiram Revels had only been a citizen of the United States for 2 years since the adoption of the 14th Amendment. But the Constitution requires that you be a citizen of the United States for 9 years if you're going to be a United States senator. So the Senate had to decide, was the Supreme Court right? Does its decision in Dred Scott bind us now in this question about Hiram Revels? Was he not a citizen because of what the court said? And that's what the Democrats, of course, all argued. And the Senate said, great, sit down. Hiram Revels is seated. We think you were wrong. We think you're crazy. You lost the war. And we're not bound by the interpretation of the Supreme Court. The Supreme Court doesn't bind on parties. I can give all sorts of other explanations for this. And so I just think that's wrong. APA vacatur, okay. I've not written on this, okay? I've read a lot of what other people have written about, and let me tell you what my sense is. If you go back to the original statutes in the states, in the original early 20th century federal statutes that say set aside, the set aside was always to an administrative order. What is an order as opposed to a regulation? Well, it's kind of like a judicial act. It applies to particular parties that were before the agency. Yes, there could be lots of collateral effect, but it applied to an order. What does it mean to set aside a regulation? Do they, when they hold a statute invalid and ignore it for purposes of a case because it's inconsistent with the Constitution, do they send a law clerk to the government printing office to revise the United States Code, to revise the statute at large? They don't do that. The statutes are still there on the books to be applied in other cases. What does it mean to set aside a regulation? Do they go in? Who even publishes the Code of Federal Regulations? There's some agency that surely does it. Like, you can't do it. It's still there. It just doesn't make sense. And I just don't think APA vacatur allows it. And if it did, it's probably an unconstitutional conferral of legislative power on the courts. That's a problem. Class action, and clearly not getting to executive power. So I'll just stop after the class action point. Class actions were around, bills of peace were around during the New Deal. And yet the Agricultural Adjustment Act faced 1,600 different injunctions, okay? A page of history is worth a volume of logic. If class actions were available, don't you think someone would have certified a class against the Agricultural Adjustment Act? But they didn't do that. They had 1,600 different injunctions, so I don't think it makes sense. And I don't think it makes sense just generally. I think the idea that class actions are a replacement here is inconsistent with the proposition that we generally disfavor facial challenges, right, to statutes, or less true with regulations now. But, look at the birthright citizenship example. What if the answer, some people, if you look at the history, maintained that if you were born in the United States to temporary visitors, to claim your United States citizenship, you had to come back upon reaching the age of majority and renounce your parents' citizenship. How can you settle that on a class action basis? That's a very fact-intensive inquiry. What if you are an excludable alien caught at the border? Under United States law, you are not treated as being in the United States, right? Versus a removable alien who is in the United States. How can you certify a class when that question might matter? How can you certify a class when someone might be deported before they have their child, and so their child actually would not have a claim to United States citizenship? The class action mechanism just often will not make sense in these cases. And so I have a lot more I could say about unitary executive too, but let me stop there.
Gary, do you want to talk about the executive?
Sure, although I don't know that I have a lot to add from what I said before, unless people do kind of jump in on some of those points.
Yeah, so this might be happen when you have a professor and a practitioner sitting next to each other.
Nothing that I say matters in the real world.
Yeah.
I want to be very clear about that. But it's right.
So I think maybe we agree that the Supreme Court disagrees with everything you just said?
Yes.
Yes, okay.
And that's in my favor, of course.
Yeah. Okay, so we will, and I'm mostly interested in what the Supreme Court thinks, not what I think about it. So I am curious, Alon, though, whether your view of your view changes when a federal law is struck down in the United States or United States agency is a party in the case. Do you think then that the federal government is bound in all cases by the Supreme Court's determination that it was unconstitutional?
I don't think it is. Call me a heretic, burn me at the stake. I think if the Supreme Court says the United States, you're violating the law, stop violating the law as to this plaintiff, I think they can keep violating the laws to another plaintiff. Maybe the judge was wrong. Maybe the Supreme Court was wrong. Eventually, the question gets settled over time, but I think a Supreme Court decision helps settle it, but I don't think Supreme Court decisions, a single Supreme Court decision settles a constitutional question much more than a single district court opinion, a little bit more than a district court opinion.
Can I ask another question?
Yeah,
Sorry
please. You're the appellate lawyer here. All my cases get dismissed before argument, so I've never had. That's because the government always caves when I see them.
So if the Biden administration had banned firearms across the board, writ large for everyone, and that went to the Supreme Court, and they said, no, obviously you can't do that. See Heller, see all of our decisions. Would your position be that the United States would then only be prohibited from banning firearms for the plaintiff that brought that suit, and that every single other firearm owner in the country would have to bring their own suit against the United States in order to get relief?
Correct. If those other individuals faced, notwithstanding the decision, action by the government inconsistent with that decision, yeah, they would have to bring their own lawsuit. And the government would have to argue, well, actually, this case is a little bit different, which it might be. And isn't that why we have these issues decided on case-by-case bases like these? So yeah, call me a heretic, burn me at the stake.
Okay.
Beth, want to jump in?
Appreciate the pushes.
No, I'm interested in the certainty that there are 5 votes with set aside. I agree that there are signs, but I don't know if it's a foregone conclusion.
Do you think it's the chief who's in play?
Well, look, being on the DC circuit and using this tool over and over and over, I think certainly would feed into your thought process that is probably an appropriate tool. However, if they're looking at it afresh, not bound by DC Circuit precedent, I think it's an open question, and I think you put your finger on it, because the fact that they didn't rule on constitutional grounds in CASA means that it's open for Congress to talk, to legislate on. Congress could come back now and say, no, set aside. We think that we should stand to thwart the administrative state yelling stop. So, we want to be very clear that set aside means, as to everybody. Or conversely, no, we don't want judges to have that much power, and set aside is actually only to the plaintiff in the case. Not ruling on constitutional grounds in the way they did leaves that open for Congress.
Yeah. No, I think I would be very surprised if Justice Kavanaugh shifted his position after his corner post decision. You're right, though, that I think that I'm remembering correctly. Someone tell me if I'm wrong. I don't know that the chief is on written record on this.
It's just the breakfast thing.
It's the breakfast thing during the Texas argument. Yeah. So we'll see. But I think we're on the same page that this is a statutory interpretation question.
The same is true of Wilbur Bright, by the way. They didn't decide it on Article 3 grounds, kind of raising this question of whether Congress could recreate a Chevron framework, which they probably can in public rights cases, probably not in private right cases, but I don't think we're talking about public and private rights.
I would say it's a statutory interpretation question now. It could become an Article 3 question.
Yeah.
And riffing on that, one of the themes has been shifts of power, especially from the executive to the judicial. Will the mode of statutory interpretation the courts employ when deciding these questions, textualism, purpose, something else, will that affect the shift, not just where it will go, but will a textualist approach always return power to the judicial branch, or does it go both ways?
I can start. So I think when you return the interpretive power to the judicial branch with Loper Bright, you have to then police the judicial branch, and the job of doing that is at the Supreme Court. I worry a bit that with this reinvigoration of judicial power without any executive deference, that the lower courts will run amok, as in my view they had done with unlawful nationwide remedies, and the Supreme Court will potentially have too much on their hands to fix everything. So I think that is a risk. One way the Supreme Court can do this is by establishing doctrines like the major questions doctrine, but that of course entails judgment too. And at the end of the day, you really need to have judges up and down the system who are willing to follow the lead of the Supreme Court.
Other thoughts?
Maybe this is controversial, but I often kind of, when I'm thinking about the court, ask, what's the tail and what's the dog in terms of who's wagging what. And I think when we're talking about modes of statutory interpretation or even questions of originalism, by the time we get to the court, there are robust kind of thought out positions on both sides, applying whatever the statutory canons are or looking into kind of the historical record, and the court has a choice on which narrative. I mean, really, if you look at most of the court's decisions, including CASA, you have, Justice Barrett lays out the majority's view on whether there's a historical analog to universal injunctions, and then Justice Sotomayor, citing all of Professor Sahoni's research, kind of lays out the opposite position. So if reasonable minds can disagree on all of that, I think in the end, the court's just being much more practical in kind of reaching, right? So you have this sense, they had this sense in CASA, I think, that they had built up over a number of years, that universal injunctions were bad and that class actions were a good alternative to that. And that was kind of where it was going to go. And then we all made our arguments, and that's ultimately where it was. I don't know that the mode of statutory interpretation or kind of constitutional analysis ultimately makes that much of a difference when we're talking about shifts in power.
Can I provoke our friend at the White House?
Yes.
Okay. So I want to say one thing about the removal power. I think the president has a removal power. I think it comes from the proposition that the executive power is the power to oversee the execution of the laws. You can't do that alone. So the appointment of officers was understood to be a quintessential element of the power to execute, to oversee execution. And it was a common law maxim that he who appoints also removes, if for no other reason than by making a new appointment. And in 1789, they debated the consequences of sharing the removal power with the appointment power between president and Senate. Okay, does that mean that president and Senate together must remove? Does it mean that ultimately both appointment and removal are derivative of executive power, and that only appointment is given to the Senate, so the president keeps the removal power? What's the implication of the take care clause? Whatever you think of the merits, of that particular decision in 1789, it seems quite right to me as a textual and structural matter that the president can fire anybody he wants. Does it, principal officers, does it follow that the president has a constitutional right to direct them and control them? Many statutes give the president that power. But I don't know, here's what Washington said when someone asked him to interfere or get involved in a voucher, a pension claim. Washington said, "My public situation forbids any interference of questions of individual claims, otherwise as they may come before me through an act of Congress, a private bill. This will be satisfactory to you for my declining to direct any investigation of the vouchers that you mention." In another letter, he says, "I have no power, nor would there be any propriety in my interfering with the settlement of accounts, at least unless it be in the case of malpractice of the officers." There is Daniel Webster when he was fighting Andrew Jackson on the withdrawal of the deposits from the Bank of the United States. And this was like the first Saturday night massacre, except I think it occurred like on a Monday, where Jackson had to sack 2 Treasury secretaries for refusing to withdraw the U.S. Treasury deposits for the Bank of the United States. And here's what Webster said. "All are able to see the difference between the power to remove the secretary from office and the power to control him in all or any of his duties while in office. The law charges the officer, whoever he may be, with the performance of certain duties. The president, with the consent of the Senate, appoints an individual to be such an officer, and this individual he may remove if he so please. But until removed, he is the officer and remains charged with the duties of his station, duties which nobody else can perform, and for the neglect or violation of which he is liable to be impeached. The president, it is true, may terminate his political life, but he cannot control his powers and functions and act upon him as a mere machine while he is allowed to live." Now, Andrew Jackson provides, some counter evidence for this too, but we have the notes of his cabinet meeting and the speech that he gave in the cabinet meeting, and even he was bending over backwards. Now, this General Jackson, he imprisoned a state and federal judge during the War of 1812. Okay, so it's like, you know who you're dealing with. And even he said after his speech on the deposits, don't mistake this for a spirit of dictation, which I would resist and avoid, but rather happy would it be if what I've told my cabinet produces a spirit of uniformity among the members of my administration, right? Okay, like, so even he thought there were some limits to his ability to direct and control. So all this is a way of saying, can the president really direct all of these things? Now, I know what you're going to probably say, which is, thank you, you're an academic. This is the real world. How else are we supposed to operationalize this? Fair enough, but what's your take on all that?
I think first there's a distinction between legal limits and prudential limits. I think there may be some cases where maybe for various reasons, President Jackson doesn't want to say, I'm directing you to do X. It'd be great if you came to that conclusion on your own. And by the way, if you don't, you're going to be fired. I think that's a pretty compelling argument in of itself. But I mean, ultimately, the executive power, though, is vested in the president. The authority the other officers are exercising is, by and large, the president's authority through the various allegations and the various delegations in the executive branch. Ultimately, I think it is his authority to exercise as he fit. And I think whether you view that as a formal matter, as the president directing it, or a sort of prudential matter of, the president strongly suggesting, and by the way, if you don't want to do it, you might want to start looking for their job. I think the end result ultimately comes out.
We have a few minutes for questions. There's a microphone here, and I believe over there. Please give your name and affiliation. If there's a particular speaker to whom you're directing it, or the full panel, let it know. And I have moderator prerogative. If it becomes a declaratory sentence, I am going to change it to an interrogative.
Devin Watkins, my question is for Professor Worman. If we have such a limited view of how far even Supreme Court justice opinions apply, do we need to have personal retroactive liability for the harms of rights by federal officials to ensure that they have the incentive to actually follow the law?
If we're doing originalism all the way down, the answer is yes, and the answer is the Westfall Act is unconstitutional to the extent it does, under the necessary and proper clause, to the extent that it eliminates classic tort liabilities against government officers without replacing it with a scheme of government indemnification, which Congress could easily do and solve this problem. But yeah, great question. Burn me at the stake. Again, that's like, this is originalism all the way down. If
So
you
can
really
I get you on a pro-Bivens brief sometime?
a separate problem, yes. That's a cause of action, yeah.
Hi, my name is Brandon Sharp. I'm a law clerk. My question's largely Professor Corcoran, but to the extent it implicates things that don't matter in the real world, Professor Worman, please jump in. So Professor Goldsmith has suggested that CASA may have erred in looking to the Judiciary Act of 1789 because the case is a 1331 case, and Section 11 of the Judiciary Act does not cover 1331 case. Maybe they should have looked to 1875, where 1331's predecessor was brought about. So is Professor Goldsmith right? And if so, does that mean we have to pass a law to give that equitable power, or what is there a solution, or does this all not matter?
Yeah, it's a really, are other people familiar with Professor Goldsmith's, it started as a tweet, I think, and eventually became a blog post. I think it's really interesting. So what he was pointing out that, federal question jurisdiction is Section 1331. That was certainly the basis for jurisdiction that we cited in our complaint. I don't recall, the reason that the Judiciary Act of 1789 loomed large, I think, in the court's thinking on it was because that was the statute that was issued in Grupo Mexicano. If you listened to the argument, you heard us talk about Grupo Mexicano a lot. What's interesting about Grupo Mexicano, though, is it didn't actually, when the court was doing its analysis there, it didn't limit itself to looking at kind of the state of the law of equity powers in 1789. I think most of the cases and examples that the court cited in Grupo Mexicano were from, it was like 1870 to 1920 something, right? So that would be the same period, and that was one of the points I made during argument, and that Professor Sahoni has made. And you do have examples of universal injunctions during that time. One of the reasons you don't see universal injunctions against the federal government sooner is for exactly this reason, right? You didn't really have these kind of big constitutional challenges or statutory challenges to the federal government until you got federal question jurisdiction under 1331. So I think it's a really interesting point. I think if the court were to consider it based on the analysis in Justice Barrett's decision, it would end up at the same place it did otherwise, because the state of the law in 1875, you're looking at kind of a lot of the same cases. It's interesting, though.
Cool. Thank you.
We've got time for one more question.
Hello, my name is David Latt. I read a Substack newsletter, Original Jurisdiction. Not to pick on Professor Worman, but I'm guessing you would know this literature really well. What are your thoughts on the originalist case for the originalist case against the unitary executive, and work by Caleb Nelson and people like that saying, well, it's actually not so clear. There's a lot of overlap. If you go back to the founding, Congress had various ways in which to shape, the appointment and retention and removal of executive officers. So I was just curious, how clear-cut do you think it is?
That's a great question. And let me first say, it depends on what you mean by unitary executive, right? If removal of principal officers is all you mean by unitary executive, I actually think the case is pretty darn clear-cut, subject to the possibility that under the common law maxim of removal follows from appointment, the Senate and the President together should be able to do the removal. But what's interesting, the position of modern academics, the position of Brandeis, the position of others, has been that Congress, under the necessary and proper clause, has the power to do it. But actually, under the common law and the text and the structure, there are really two plausible positions: either President and Senate together, or the President alone. Through those various structural extrapolations, this view that Congress has discretion seems to me to beg the question of what is the executive power, right? Because if the executive power includes the power to remove, then Congress saying you could only exercise that power for certain purposes, right? You can only remove for specified causes, seems to me just as crazy as saying Congress, which has the greater. So the argument under the necessary and proper clause is this greater power to establish the officer and the office in the first place by law includes the lesser power to do various things, qualifications, maybe bipartisan composition, and to structure the removal of the officer. But Congress has the greater power to create federal crimes. Does it follow that it has the lesser power to tell the president he may only pardon individuals for specified causes? That strikes me as crazy. Now, if the unitary executive can command and control and can personally execute the law, which is like the Cypher-Kosh position, I don't think that's right. And actually, there isn't much evidence for that view. But as our friend from the White House has said, practically, does it really matter that much? I actually think it does a little bit, but maybe not all that much.
Thank you.
Our next event is in the International Ballroom for a fireside chat with Deputy Attorney General Todd Blanche, starting at 2 o'clock. Please join me in thanking this panel.